Select Committee as well. So thank you.
I call Asanati Lole-Taylor.
Thank you, Mr. Speaker. I am pleased to have the opportunity to speak on the administration of community sentences and orders bill on behalf of New Zealand First. I acknowledge the effort by the Minister to have this bill introduced to the House. It was March 2009, Mr. Speaker, when an expert panel was established to work with community probation services in releasing a comprehensive change program. 3 years since then, another bill is being introduced to the House in order to address what was meant to be addressed by this so-called change program, which had been allocated huge funding through the Department of Corrections. The change program focuses on sentence compliance, which means better targeting of time, effort and resources according to the risk each offender presents. There is a need to ask what the Minister and her staff have been targeting, given that a sex offender had been working with the school students under multi-identities, and one can only hope that it was not another case like the former ACT MP. Furthermore, how are the security screening being processed? The change program, led by Paula Ripstock, had 6 key recommendations of the expert panel. Sentence compliance will continue to be a major focus, but Community Probation Service will also concentrate on 2 other key areas. Those 2 areas were reducing the likelihood of offenders reoffending and minimising the risk of harm to others. The other part was about establishing a Chief Probation Officer, and I hope that has been done. Shift from clarification of risk to the management and reduction of risk. Move from a highly prescriptive and procedure-based framework to one where more professional judgment is used. I suppose, in other words, that means applying common sense. Promote clearer accountability and greater responsibility among staff, and significant gains can be made from a fundamental rethink and redesign of probation activities. I looked at the general policy statements of this bill. The general policy statement says that the bill highlights certain provisions that have been identified as barriers to managing offenders in the community in a manner that is safe, secure, humane, effective and efficient. To say that current legislations provide sound framework for operations of the correction system is interesting, though. If current legislations are effective and sound, then we wouldn't be debating this bill right now. I think it is astounding that the government has taken so long to introduce a bill to address administrative issues arising from sentencing and parole reforms. The bill considers nearly 50 legislative amendments to be made concerning the Bail Act 2000, the Parole Act 2002, and the Sentencing Act 2002. Each amendment proposed seeks to remove certain legislation barriers involved in the administration of sentences and orders so that clarification is reached, and many governmental agencies involved improved on their operations. The legislation amendments would change policies concerning home detention, community-based sentences, and electronic monitoring regimes. It is imperative to have complete transparency when it comes to community sentencing. It is alarming that with the current law in place, there is room for uncertainty, which can often result in legislation interpreted in different ways and can be ambiguous to concerning parties. Ensuring compliance with sentences and orders and managing offenders safely and humanely is, of course, essential. It is important when we are dealing with offenders who are sentenced to home or community detention to clarify each circumstances faced and proposed, including assessment of home situations, effects of subsequent sentencing of imprisonment and prevention of impositions of sentences with those existing. Compliance from the offender to his or her community sentence should not be waived because of electronic monitoring faults. Responsibility for preparing reports to the parole board on suitability for residential restrictions requires clarifications. The current allocation of responsibility to probation officers does not cover the provision of information relating to the offender's behaviour in prison. Mr. Speaker, despite many meetings at all levels over a number of years between prison service and community probation service in regards to ensuring there is seamless flow of information between the two agencies, very little beyond lip service has happened. I would have to say that the issues are simply around patch protection. Frankly, this is not good enough. CPS, or Community Probation Service, must have access to Prison Services Integrated Offender Management System to allow access to key prisoner information that covers the prisoner's behaviour while he or she is in custody. This would include access to prison file notes, incident reports and misconduct on IOMs. For years, this has been a request that has been continually put off. There will be very little in the way of fiscal or administrative impacts to allow such access. There should be no loopholes concerning the protection of our communities against potential reoffenders who have committed sexual offences, and extended supervision orders are an important prevention. Extended supervision orders conditions should apply immediately, even if the release date is on a non-release day. The legislation concerning extended supervision orders must be clear so that parole boards have the power to impose release conditions on extended supervision orders. With the current cases faced of undetected sexual offenders working within our education sectors, it is no laughing matter. Insurance of this not happening again is essential. Victim rights need to be reinstated, as the Parole Amendment Act 2007 has left victims with no entitlement to accessing information on hearing or its processes. New Zealand First agrees with the extensive changes need to allow for transparency. We will support this bill on its first reading. However, a look into the scope of accessibility of prisoner information for community probation services staff is one which needs consideration. This bill will do well with the introduction of the New Zealand First Short Sharp Sentencing Bill. I support this bill to the Select Committee. Thank you.
Call Jamie Lee Ross.